If you are over 50 and you keep cash at home, you need to understand something that millions of Americans still do not realize until it is far too late. The next time a police officer, an IRS investigator, a Medicaid caseworker, a creditor, or even a family member asks where your cash came from, your answer alone may no longer be enough. It's my savings. It came from Social Security. It came from my pension. I've been putting money away for years. None of those statements automatically protects you anymore, because in 2026, large amounts of undocumented cash can trigger scrutiny, investigations, legal delays, asset freezes, and financial complications even when the money was earned completely legally. And that is the part that terrifies innocent people the most. You can be entirely honest, entirely lawful, entirely innocent, and still find yourself trapped inside a legal system demanding proof you never realized you needed. Maybe the cash came from decades of careful saving. Maybe it came from a car sale, an inheritance, side work, a home emergency reserve, a distrust of the banking system after 2008, or simply years of withdrawing small amounts over time because keeping physical cash nearby made you feel safer. But once significant amounts of undocumented cash are discovered, the system often shifts immediately into suspicion mode. And there is one number Americans over 50 especially need to understand. Research involving civil asset forfeiture investigations and IRS structuring cases shows that cash amounts above roughly $5,000 during a single interaction become dramatically more likely to trigger scrutiny. That does not mean $5,000 is illegal. It means the risk profile changes above that level, and millions of Americans over 50 currently keep far more than that inside homes, safes, drawers, garages, or hidden storage locations. Not because they are criminals, because they are cautious, because they remember bank failures, economic crashes, power outages, financial instability, and systems they no longer fully trust. But the legal environment around home cash has changed dramatically over the last 20 years. And today, I'm going to show you the 4 biggest legal traps that can turn completely legitimate home cash savings into a nightmare involving investigators, lawyers, insurance disputes, Medicaid problems, or frozen assets. More importantly, I'm going to show you exactly how to protect yourself before any of that happens. The first danger is civil asset forfeiture, and this may be the most misunderstood legal threat facing Americans who keep significant cash at home. Under civil asset forfeiture laws, law enforcement agencies in many jurisdictions have the power to seize cash they believe may be connected to criminal activity. Read that carefully. In many situations, they do not need a criminal conviction first. Sometimes they do not even need criminal charges. The legal standard for seizing property can be far lower than the standard required to prove someone committed a crime. And this is where ordinary law-abiding people get caught. Not drug traffickers, not organized criminals, retirees, small business owners, veterans, widows. People who simply saved cash privately for years without maintaining detailed records. Once large amounts of cash are discovered during a traffic stop, home inspection, estate dispute, or other legal interaction, suspicion can begin immediately. And once suspicion begins, the burden often shifts partially onto the owner to prove the money came from legitimate sources. That becomes incredibly difficult when the savings were accumulated slowly over decades. Jerry Johnson learned this the hard way. Jerry was a 67-year-old retired nurse from Florida who saved approximately $40,000 over many years after living through a bank failure earlier in life. He trusted physical cash more than financial institutions. While transporting $8,600 to purchase a used camper, he was pulled over for a broken taillight. Officers seized the cash. Jerry was never arrested, never charged, never accused of any violent crime. But it still took nearly a year and more than $4,000 in legal fees to recover his own money. He later said, I spent 30 years saving that money honestly, and suddenly I had to hire a lawyer to prove it belonged to me. That is why every American over 50 who keeps emergency cash at home needs what I call a cash source document. It can be simple, a written log explaining where the money came from, when it was withdrawn, which account it came from, whether it involved a property sale, inheritance, pension, or personal savings. It does not need to be complicated, but it needs to exist because your memory is not evidence. Documentation is. The second danger involves IRS reporting rules and something called structuring. And this is where many completely innocent retirees accidentally create legal problems without even realizing it. Most people know banks file reports for cash transactions above $10,000. That report is called a currency transaction report. And contrary to popular belief, that report itself is not dangerous. It does not automatically trigger an investigation. It does not mean you are suspected of wrongdoing. But many Americans hear about the $10,000 threshold and make a serious mistake. They intentionally keep withdrawals below that amount because they believe smaller transactions look safer. That creates what federal law calls a structuring pattern. And structuring itself is a federal crime under the Bank Secrecy Act. The government does not need to prove the cash was illegal. They only need to prove transactions were intentionally arranged to avoid reporting requirements. That means someone withdrawing $8,000 one month, $7,500 the next month, $9,000 later, may accidentally create a pattern investigators interpret as deliberate reporting avoidance. An Ohio retiree experienced exactly this situation. Over 18 months, she withdrew amounts between $7,000 and $9,000 because she wanted to build an emergency cash reserve outside the banking system. She believed staying below $10,000 was the smart thing to do. Instead, the pattern triggered scrutiny. Her account was flagged and eventually reviewed by federal investigators. She was never charged with a crime, but she still spent 8 stressful months dealing with lawyers, interviews, document requests, and federal scrutiny simply because she misunderstood the rules. Here is the critical lesson. If you need to withdraw large amounts of cash, do it honestly in a single transaction. Let the bank file whatever report it is legally required to file. That report is normal. That report is routine. And it is dramatically safer than creating a withdrawal pattern that appears intentionally structured to avoid reporting thresholds. The report itself is usually not the danger. The pattern is. The third danger appears during ordinary life events. No police raid, no criminal investigation, just normal legal processes, a Medicaid application, an estate settlement, a divorce, a bankruptcy filing, a property dispute, long-term care planning. In all of these situations, undocumented home cash can suddenly become a major legal complication, and Medicaid creates one of the biggest traps of all. Most seniors do not realize Medicaid uses a 5-year financial look-back period when evaluating eligibility for long-term care assistance. That means agencies review years of financial activity, searching for unexplained assets or transfers. If large amounts of undocumented cash appear during the process, questions immediately begin. Where did the money come from? When was it withdrawn? Why was it kept outside the bank? Why does the amount not match available records? And if those answers cannot be documented clearly, Medicaid approval can be delayed for months. Beverly Cartwright experienced this firsthand. Beverly was a 73-year-old widow in Tennessee who had slowly accumulated roughly $22,000 in home cash savings over many years. When her husband required nursing care, she applied for Medicaid assistance. The undocumented cash immediately complicated the application. Most withdrawal records no longer existed because Beverly never imagined she would someday need decade-old paperwork proving the source of emergency savings. The result was a 5-month delay while her family attempted to reconstruct financial records from old bank statements. Meanwhile, nursing care expenses continued accumulating out of pocket, all because simple documentation had never been created. But there is another financial danger most homeowners never realize until after disaster strikes. Insurance. Most standard homeowners' policies cover shockingly small amounts of physical cash, in many cases $200, $500, or at most $2,000. That means someone keeping $10,000, $20,000 or more at home may discover after a burglary, fire, or tornado that nearly all of it is uninsured. One retired Arizona couple lost $18,000 stored inside a home safe during a burglary. Their insurance reimbursement for the cash? Only $200. The rest was simply gone. Their insurance agent later explained they would have needed a separate rider or endorsement to properly insure large cash reserves, and nobody had ever warned them. Now let's bring everything together. The problem is not keeping cash at home. Millions of Americans do it for completely understandable reasons. The real danger is keeping large amounts of undocumented, uninsured cash without understanding how today's legal and financial systems operate. Because in 2026, civil asset forfeiture laws create seizure risks, structuring laws punish certain withdrawal patterns, Medicaid reviews create documentation problems, insurance policies often barely cover home cash losses, and none of these problems require criminal intent. That is why every American over 50 who keeps emergency cash reserves needs a protection plan immediately. Step 1. Create a written cash source document today. Record the source of the money, dates of withdrawals. Account information, reasons for keeping the reserve, keep copies somewhere secure. Step 2. Stop breaking large withdrawals into smaller amounts to stay below $10,000. If large cash is needed, make straightforward legal withdrawals and allow normal bank reporting procedures to happen naturally. Step 3. Call your homeowner's insurance company this week. Ask 2 questions. What is my current cash coverage limit? And what would it cost to increase that limit with an endorsement or rider? In many cases, expanded coverage costs surprisingly little. Step 4. Before any major legal or financial event involving asset reviews, including Medicaid planning, estate settlements, or long-term care applications, speak with an attorney, CPA, or financial advisor first. Preparing documentation early is dramatically cheaper than reconstructing years of records later during a crisis. And finally, understand this. The people most likely to get blindsided are not criminals. They are ordinary Americans who believed physical cash alone was enough protection. In today's legal environment, it is not, because cash in 2026 now requires documentation, legal awareness, and financial planning in ways it never required 20 or 30 years ago. The rules changed. Most Americans over 50 were simply never told.